My lord, my lady, I appear for the appellant with Mr. Jupp, now King's Counsel, was junior counsel below, and Mr. Hare appears for the respondent, the General Medical Counsel. I shall refer in my submissions, my lords and my lady, to the parties as claimant and respondent, so as they were below, to avoid confusion at
Very helpful,
the stage. Just before I start, if I may, just to check that your lordships and your ladyship have all the relevant documents. You should have an agreed core bundle, an agreed supplementary bundle. You will also have 2 applications to introduce an agreed bundle for the respondent and, on a contingent basis, an agreed bundle for the claimant. I hope you got the message yesterday that we won't resist the respondent's application to introduce this bundle of documents. Do you have those? Does that...
No. Well, sorry, the first thing to say, just embarrassingly, is I left my core bundle in my room, but I have it. I hope it's at home, there on the home, but I'm pretty sure I have it, so that'll be coming in a minute. But I was aware of the application, but I'm afraid I hadn't certainly grappled with it, because these things tend to solve themselves.
Well, it has.
And
that's good. But
you don't have the bundles. Right.
Yes.
Well, that's...
The good news is it's not opposed, but the bad news is there's no respondents.
Well, is it? Well, hang on. Is it?
We have an unagreed supplementary bundle.
I assume that's what you were talking about.
Is that it?
I think you said respondents, but perhaps that was a slip.
Well, there's 2. You should have 1 for the respondent and 1 for the appellant.
We haven't got the respondents.
We have a supplemental bundle, but no, we haven't. We've only got 1 unagreed bundle.
You ought to have 2 agreed bundles comprising a core bundle and a supplementary bundle.
Yes.
You then ought to have 2 further bundles.
Yes.
No, only one.
Only one.
And
that it's called appellants. It's not called respondents.
Well,
and therefore,
and it's not being
to be
melded.
absolutely clear with it, it's got 50. Oh, hang on. No, so not hang on. It's 169 pages.
I did wonder if they'd been put together.
Yeah, I wondered that.
But I'm afraid that's not the answer,
Sadly
my
not.
lady. No.
Right, well, that's
So
a
we need to find
blow. What's in it, and how central it would be to either party's submissions?
Well, if it's going to be introduced by the respondent, and as I've indicated, we don't oppose that, given how matters have developed, I will have to refer to it in my submission.
Yes.
The documents in it in my submission.
What's in it?
What?
I beg your pardon, what's in it? I didn't answer that question. They are a selection of documents from the larger bundle, much larger bundle, before the Employment Tribunal and the Employment Appeals Tribunal.
It did occur to us in our pre-discussions that the parties, well, we were thinking perhaps this was a matter of congratulation, had been very austere about what we had been supplied with from the evidence below, but given the way in which the arguments were put, I thought perhaps that was a choice, but evidently not.
Well,
when were they... If you... I don't want to do a forensic examination from here, but if you can tell me quickly when they were filed, then we can establish whether they're sitting in the office somewhere.
Yes. Well, they were certainly filed sometime before the claimants, because that's in response to trying to put in the additional bundle. So it was a matter of weeks ago, my lord, that the GMC's unagreed bundle was sent in. And the application, I think, dated from January.
Well,
mid-January.
Yeah, the application was made in January, with the documents attached to the application.
Unless they made a mistake, which I don't suppose they have. It's sitting around on a shelf somewhere, nobody spotted it. Can you do some detective work? Best of luck. Apparently it was some weeks ago. So that... Can you tell us when?
Of course you can.
We're told it's the 16th of January.
That's when the application was made, and the copies of the bundles
were with the application.
There was a copy with the application.
So yes, and I think. Sorry, read a bit more.
Of course.
If it was filed with an application, so I don't know how much you see 1256A rather than 1256. That's a guess. Do your best. Thank you. Well,
my lord,
normally we stick up for the institution and say it must be the fault of the parties. Your account sounds pretty plausible, and therefore we probably have got the bundles in the building, but they haven't reached us. My clerk, or my stand-in clerk for today, is to go and have a look.
my lord, I was sorry to interrupt, but we do have a clean version, and I wonder if it would be helpful for your clerk to have it. So
it knows
she
what
can
it looks
actually
like.
see
Yes,
what it looks
that's-
like. If that
Yeah,
would be
that's a very good
It's a
idea.
very small bundle. So, thank you.
Right.
Your surprise at the.
Do we know that it's filed electronically?
The application certainly was, but copies of the bundle were also provided on the 29th of April. That's the second date time, as it were.
What?
the
So they were
application-
filed twice?
Well,
Yes. So the electronic bundles were filed with
So
the
the
application,
sorry,
and
the
the hard copies were
the
delivered
hard
on
copies were
29th
sent on the
of
20th.
April.
Oh, I see.
Yes.
Okay, that's fine. Well, look, I think I don't want to hold up the hearing, but obviously we don't want anything to happen unfairly. I think we will proceed for the time being. My clerk will come back in however long it takes. It'll take a minute or two if they've got lost, but with a bit of luck, might come back in half an hour or so. Probably, I think we'll just have to take stock at the moment we come to an important document. One point that occurs to me is if they were filed electronically, we can go back and get our laptops, which none of us have brought, and can look at it online. But I think we're all paper people by preference. Otherwise, we'd brought our laptops in the first place. So can we deal with it in that way?
Certainly.
Or we may have to rise if we get to an important document and it hasn't appeared in the meantime.
And it may be I'll organise my submissions in a way that I can.
If you can do that without prejudice to your clients,
yeah,
that would be great. Well, I'm sorry that's happened.
Not at all.
And
Not at all. My lord, just so then we can be completely clear, you ought to have had as well a revised core bundle only to add updated skeleton arguments at the end of the bundle.
yes, and updated only in the sense that references have been added.
Precisely.
Yes,
My
right.
lords.
Well, I can't say we have everything. We have identified what we don't have.
My lords, then, as your lordships and your ladyship will have seen, this is an appeal against a decision of the Employment Appeals Tribunal, allowing an appeal against a decision of the Employment Tribunal that upheld certain of the appellant's complaints of race discrimination. I will, of course, need to take your lordships and your ladyship to the decision of the Employment Appeals Tribunal, but since this is a second-tier appellate court, my submission, your primary concern will be whether or not the Employment Tribunal decision is robust enough to survive the scrutiny that this court will now apply to it. So I'll start with the Employment Tribunal decision. I'll deal with it as efficiently as I can, but I do have to take some care in going through it because so many criticisms were made of the Employment Appeals Tribunal about it. You'll find that in the core bundle at page 109. And as perhaps will have been obvious to you on reading the judgment, the Employment Tribunal's judgment, there was a list of issues agreed between the parties. I don't need to take you to those. But
Well, can we just be clear about that? I found in the supplementary bundle what was described as list of issues for ET hearing. And I had a look. Is that the one you're referring to?
Yes.
It's described not as an agreed list of issues, but as a draft list of issues on behalf of the claimant. And so far as the less favourable treatment is concerned, it really isn't a list of issues in the normal sense. It's simply plucking out the relevant part of the claim form.
Yes.
And that's not a criticism, but it's not normally what one understands by a list of issues.
Well, it's been described as a list of issues.
Well, was it agreed? I mean, essentially, it couldn't be unagreed because it was simply saying what your case was.
Precisely, and it was reflected in the order adopted by the Employment Tribunal.
Okay.
So.
Okay, I'm sorry to be pernickety, but I want to make sure we talk about the same thing.
I have assumed throughout that it was agreed, and I was below, and I'm sure I would remember if it wasn't. It is an unusual way to do it, but it frankly is not that unusual in the employment tribunals. They do adopt things like listing, less favourable treatment, and so on. But there we are. The point of identifying that for your lordships and your ladyship is just to indicate that the structure followed by the employment tribunal follows that identified and agreed between the parties. As to then the decision, just 3, if I may, introductory observations before I take you through the paragraphs that I have to take you through. First of all, as I'll come to when I address the authorities in brief, because I know your lordships and your ladyship are very familiar with them, but the purpose of reasons is to inform the parties why they have won or lost, not the uninformed reader, and it's necessary, therefore, to have in mind the material evidence and, importantly, submissions before the tribunal in order to determine whether, when everything is considered, it's apparent to the parties why they've won or lost. Secondly, it is not said in this case that the employment tribunal misstated or misdirected itself in law, nor is it said that there was no evidence to support a particular finding of fact. There was some suggestion of that in the Employment Appeals Tribunal, but for reasons I needn't trouble you with, those complaints have gone, and that one indeed was withdrawn. So no perversity allegation insofar as the absence of evidence is concerned, no misdirection, and making clear that the purpose of the reasons must be understood in the context with which we're concerned here. The complaint, in simple terms, is that as the respondent...
Sorry, you said 3 points. Is this your third point? Or perhaps you
this is still my second, forgive me.
Sorry,
So I've said there's no suggestion that the Employment Tribunal explicitly misdirected itself in law. There's no allegation or complaint that there was no evidence to support any particular finding. And so, still second point, essentially what the respondents contend and the Employment Appeals Tribunal held was that the reasons for the conclusions, in light of their unimpeachable, we say, findings of fact, were deficient, so they were Meek non-compliant, and that the tribunal fell into error in applying the burden of proof provisions, though there's a close overlap between those two things. Thirdly, and as your lordships and your ladyship will perhaps have picked up, there was a bundle of documents before the Employment Tribunal comprising 5,600 pages, only a small selection of which you have now. There was, of course, live evidence, and the claimant alone was cross-examined for 2 full days. There were also detailed written closing submissions, which you will have seen, I think, in the supplementary bundle.
Do we have a list of who gave evidence for the respondents?
You don't. I can tell you who they were, but they were various. One of the complaints we had was that many of the decision makers weren't called, but that's not a matter I need to trouble you with. That's something in the submissions. But there were 1, 2, 3, 4, 5 witnesses for the respondent and the claimant.
Thank you.
And as I've indicated, extensive cross-examination. And there were also lengthy written closing submissions. So the starting point is the parties were well aware of the evidence, of course, and they were, importantly, very well aware of their respective cases, their opponents' cases. And so when looking at whether they now know, that is, both parties, why they won or lost, they can bear in mind that they know what the cases were, what the parties were, and of course are fully acquainted with the evidence. So those are my introductory observations. If I can take you then to the decision.
Well, we're on page 109, that's one I had. Just for the narrative, at the top of the page, It says the tribunal heard evidence on 6 days, in 5, 6, 7, 8, 14, 15 October. And then it says 22 to 24 February, closing submissions and tribunal discussions. How much of the 3 days were submissions and how much were tribunal?
My recollection, it was 1 day. In fact, it was less than a day worth of submissions remotely. So the other period,
days,
or 2 days, or two plus days will have been deliberation.
There's a slight oddity about that. Hang on. It's more an oddity than I thought, but we have the closing submissions, don't we, in the supplementary bundle, the agreed supplementary bundle.
Yes.
Yes, I see, and they are dated. No doubt there was a deadline. November.
Yes.
So they were put in, and then there was a long break until, and the respondents' ones rather oddly are headed for remote hearing on 6th November 2020. It says 2020. Is that? That must be an error, mustn't it?
Yeah, it must be 21.
Must be 21. Though interesting,
No,
both parties.
The errors in the first line of the heard at, which it says 2021, when that should be 2020.
Oh.
So it should come to
So it
this
was
bit.
going to be.
Of course,
It was going to be November of 2020, and it was listed for them, and that's why I put that on my closing submission.
Yes, I see. And then something happened to stop
I
it
think
happening.
one of the members was unavailable, and so it had to be put off.
Yes, I
Some
see.
delay, then relisting it.
There was illness, and regrettably it was during the COVID period, and there were regrettably some gaps here and there for that reason.
Okay, thank you. Well, that sorts that out. It's always useful to just have the chronology right. Okay, thank you.
So, my lords, then, and my lady, first paragraph, just under the reasons, if the tribunal set out the background to the issues that it then goes on to identify. In particular, it sets out the basic facts and matters. So paragraph 1 identifies the claimant and his ethnicity and religious background, because this, of course, was a religious discrimination case. 2, that was dismissed. Identifies the respondent, notes it is a qualifications body, so falls within the scope of the Equality Act. And then sets out from paragraph 4, paragraph 3 is a historical matter that played no part in the findings and the decision thereafter. Then sets out the immediate background and provides a narrative, unchallenged, unimpeachable findings. And if I can just flick through those so your lordships and your ladyship get some clear idea about how matters proceeded, insofar as the chronology and narrative are concerned, you'll see that the immediate background for the GMC's involvement followed from an external review carried out by Professor Roche. Trust excluded the claimant and, although it's not stated there, and Mr. Laniardo, the claimant's comparator. It was a preliminary investigation, identified a number of concerns about the claimant and Mr. Laniardo, it's not said there, it did, and reports were commissioned, or an investigation commissioned, which Ms. Julia Hollywood, in due course, undertook. So, a preliminary report, a disciplinary investigation carried out by Julia Hollywood, then to follow. Respondent notified of that, as paragraph 4 tells us, and opened an investigation into the claimant and into Mr. Laniardo. That was before, of course, the disciplinary investigation report, so it's at a very early stage.
Incidentally, they describe Mr. Laniardo as one of the claimant's comparators, there were others, were
There were others,
but not relevant to any of the surviving.
not
Okay.
relevant at all to the
Thank
surviving complaints. So Mr. Laniardo is the one we're focusing on.
Yeah.
So at this very early stage, no report from the disciplinary investigator, just preliminary findings of Professor Roche and the report to the GMC. At paragraph 6, it was determined nevertheless that there was a basis for referring the claimant, and indeed Mr. Laniardo, to the interim orders panel to determine whether or not any conditions should be imposed on their ability to practice. And then in due course, a report was received in relation to the claimant, paragraph 7, on the 4th of December, that found certain allegations, 3 allegations, proved with and so we have threatening and intimidating AR on the 16th of January, influencing or manipulating the multidisciplinary team members to say another consultant's penile urethra cancer patient was discussed at a multidisciplinary meeting when it hadn't been, and thirdly, that the claimant intended or attempted to interfere in evidence that was going to be given by a Dr. Robinson in relation to a complaint about Mr. Motawala. So those were the 3 complaints upheld. I don't know whether or not your lordships and your ladyship have picked up what the MDT issue is. Perhaps it's
Better for you to say.
I'll say just in that nothing turns on it, but just because you'll see various observations made about it from time to time. The allegation was that the claimant and others wrote a letter knowing the contents to be false, stating that a particular patient had urethral cancer and was therefore discussed at the MDT.
Yeah, I see. So it is just the same. It is the point about whether it was discussed and saying it wasn't, but it was done in a letter. That's why it's.
But additionally, the importance of it was, or the further significance of it was, that if it was penile cancer, it should have gone down a completely different pathway. So the suggestion was, you're making it up that it was urethral because you didn't follow the right pathway, and then you're covering up that by suggesting it was discussed at the MDT, where urethral cancer would be discussed. So that was the allegation, a serious allegation made against Mr. Laniardo as well. I'll come to what happened to him in due course.
But weren't the allegations slightly different? But Mr. Laniardo, it was that he had allowed himself to be a signatory, whereas the claimant, the suggestion was that he had effectively orchestrated it or even drafted it. So different qualitatively and the level of seriousness.
Well,
the allegations.
my lady,
I understood. I mean, please correct me. That's just my reading.
Well, in my submission, that wouldn't be the correct reading. For a consultant to sign a letter and to suggest
I'm just saying the fact. I was just looking at the factual allegations. Of course, we'll hear your statements as to whether or not they were qualitatively different for all the purposes that we're aware of.
Yes.
As a comparator, so I'm not trying to undermine your comparators argument.
I'm simply making the observation at this stage that I think your ladyship expressed it as allowing himself to become a signatory. I would express it differently, and that is he signed the letter. It was a positive act. And if he knew the contents of that letter were false, then that, of course, is a serious matter for a consultant as well. But yes, I understand.
Just remind me how many signatories there were.
There was
13.
13, yes. I recall
13.
that 13, 11 of them we'll see in due course, said they couldn't see the problem with it. And in due course it became clear that it was urethral cancer, it wasn't penile cancer. So the suggestion underlying it that this was a cover-up fell away because, of course, if it was urethral cancer, it followed the right pathway. So that was the MDT allegation. Carrying on through the Employment Tribunal decision, the respondent's registrar decided at paragraph 8 of the decision that the Dr. R, that's the Dr. Robinson allegation, merited investigation along with the other matters set out in the terms of reference of the Hollywood report, and I would have taken you to those, but I can deal with that later.
Incidentally, it was just the Employment Tribunal that decided to refer to some of these people by initials and some not. There's no confidentiality issue at all.
And you may have picked up His Honour Judge Taylor making a remark about that last week in one of his judgments. I don't know if you're referring. That's what.
I don't read all His Honour Judge Taylor's judgments, though. I do read most of them.
I'm plainly not an allusion to that then. Yes, he made the observation last week in a judgment that the same practice had been adopted in a case that he was hearing an appeal in respect of, that is, the initials were used, and he said, in the interests of public justice, unless there's an anonymity order, people's names should be set out in the judgment. Yes. But there you are.
I think it's all going to be affected when the Supremes get around to handing down Abbasi, I think.
Well, there we are.
Well, we don't have to go into this at great length. Conventionally, patients are kept anonymous. Doctors, on the whole, aren't. But anyway,
it was the scheme that was adopted, and it may be that we led them along that route.
It doesn't really matter. It was simply so that to make sure that when we come to write judgments, we're not breaking any convention by giving their full names, which I'm pretty sure is what we'll want to do.
There were no anonymity orders, so there would be nothing to.
Yeah, and in fact, I think the EAT certainly refers to Laniardo by his real name.
Yeah.
No, I think they obviously thought it was just made easier reading. Actually, it makes less easy reading because I never know whether Robinson is Robinson or R is Robinson or Rao.
Yes.
But there we are. Okay, enough of that.
But there we are. That's the practice they adopted in here, and there we are.
Fine.
So we have the. So I was just at paragraph 8, I think.
Yes, you were.
So paragraph 8, matter concerning Dr. Robinson, merited investigation, so was pushed forward along with the other matters set out in the Hollywood report. Paragraph 9, there was a further complaint made about the claimant in that he had made contact with a Dr. Hayter, no suggestion that there was any lack of transparency, but he had made contact with a Dr. Hayter to gather some information in support of a Mr. Motawala, a professional colleague of his, when knowing Mr. Motawala was not entitled to gather that information himself. Now, that was treated as a rather less serious allegation. There's no suggestion that he covered up or hid anything from Dr. Hayter, but there we are, that was added too. And 2nd of February, it was decided that the findings in the Hollywood report, which was in due course, and the matter concerning Dr. Hayter merited referral. So
that is the first of the episodes with which we're concerned.
First complaint. So there had been at paragraph 6 of the decision a referral to the IOP in November. No conditions were imposed. You saw that at paragraph 9. No conditions were imposed. Sorry, paragraph 6. No conditions were imposed. Same with Mr. Laniardo. It's dealt with under the issues that I'll come to in due course. But an application made a second time in the case of the claimant, and as your lordship says, that's the first extant complaint.
And just to be absolutely clear, the complaint is the decision of the case examiner to refer, or if you prefer, refer probably. It's not the decision of the IOP.
It's been formulated as a decision to make the application.
Yes. So the decision challenged is that of the respondent's case examiner,
yes,
whose name we don't have here. I mean, maybe it was in the papers, but it doesn't matter. But it was a decision of an individual.
Yes.
Yep.
I think it was Lucy Gatway. Anyway, it doesn't matter. I can find the name. if it would help you. Mr. Galbraith. Yes, it was Ms. Galbraith. She wasn't called by the respondent. So there was a second application. That's the subject of challenge, as your lordships already observed. And at paragraph 11, the tribunal note that the practice of the GMC was to await the outcome of internal examinations. The claimant resigned pursuant to a settlement agreement, I should say, and so matters came to an end in May 2015 to the extent that it was appropriate to await the outcome of any investigations. There was an application for a review of the conditions that was declined, and then I'll have to come back to this when we have the documents, but in February and March 2015, information was received by the GMC to suggest that the claimant had been involved in a coordinated decision to remove the hospital manager at Spire Thames Valley Hospital. That's a private hospital at which the claimant and others, including Mr. Laniardo, enjoyed private practice privileges. So a further allegation, I'll have to come to that in due course. And at the end of
hang on. I may have missed something. The whole Spire episode is not one of the, or doesn't give rise to any of the acts of less favourable treatment that are before us, does it?
No, but it is an important matter that the Employment Tribunal took into account in deciding whether or not to draw an inference of race. Okay. So, which is why I need...
Deciding whether to what, sorry, draw...
an inference of race discrimination.
Yes,
race. Yep. And just in short form, you'll see that it was referred to them persisting with the allegation, tenacity, and so on. So in the face of Spire saying there's nothing to see here, the GMC pursued and pursued. So there's no freestanding complaint, but it's one of the background matters that the tribunal took into account.
Well, that must have meant that had to be pretty fully investigated.
The allegation, forgive me, in front of the tribunal?
Yeah.
Yes, it was. It was the subject of written submissions, an argument, and it was said on the claimant's behalf, when one decides whether or not to draw an inference, one must look at the whole context and the way in which they responded to the claimant more generally. Make primary findings of fact in the ordinary way in relation to those matters, and then determine whether or not those primary findings of fact can or cannot be relied upon for the purposes of drawing or not, as the case may be, an adverse inference.
And to be fair, it was actually, although it's not live before us, it was one of the pleaded allegations.
Well, it was pleaded slightly differently.
Oh, I see.
It was not. There was a pleaded allegation that didn't succeed, but there was, as I'll come to when I come to the decision.
Yes, I see.
The Employment Tribunal was saying you're not going to win on this complaint, for reasons I'll come to, but nevertheless we are concerned about how this was addressed.
Yeah.
They make primary findings of fact in relation to that, and then when they come to their conclusions, they say this is part of the context, the way in which the GMC were responding to the claimant.
Sorry, I distracted you.
Not at all.
You were on 13.
I was on paragraph 13.
Yeah.
And I will come back to the documents on this briefly in due course. But so the Spire allegation, again included into the investigation concerning the claimant. 17th of August, IOP revoked the interim conditions. Paragraph 15, another allegation emerges or is included as part of the subject of the investigation. Although this had been, if one looks at paragraph 15, February 2016, this was an allegation that had been identified in Roche and Hollywood, so 2014, nothing had happened, but in 2016, it was decided by the GMC that it would investigate it. Investigations completed in March. Further delay while Dr. Robinson, or Mr. Robinson, they identify themselves differently, but Dr. Robinson indicated that he may no longer wish to be a witness. And then draft allegations at paragraph 17, hearing at paragraph 18. And as you will have seen, none of the allegations of misconduct were made out. There were admissions made, but nothing that founded a finding of misconduct. And no complaint about that narrative. So it's my submission, well-structured, chronological narrative, informing the parties, letting the parties know that they've understood the background and the basic chronology. Properly structured, well organised. And then at paragraph 19, identifies the claims, race and religious direct discrimination. And then I don't need to read this to you, but I do need to make some observations. Paragraph 20 to 28, the law is set out. So far as the Equality Act is concerned, that's paragraphs 20 to 24. Now, complaint was made below and is made here that there is an absence of any reference to the authorities, and that indicates some deficiency or failure on behalf of the tribunal's part. We say no, a tribunal is not bound to set out the case law, the authorities, where there's no controversy about what the law says. There were lengthy written submissions, and as Mr. Hare himself said, I'll give you the page reference, I don't need to take you to it, but as Mr. Hare himself said in his written submissions, the law in this area is uncontroversial. Supplementary bundle, page 59, paragraph 40, and indeed it is, or was for the purposes below. There was no difference, apart from style, between the submissions made on the law of direct discrimination as between the claimant and the respondent. There were no live issues indicating any dispute as to the law. The idea that an employment tribunal judge should have to type out a list of authorities or cut and paste a list of authorities to satisfy a requirement for satisfactory reasons can't be right in an area where there's no dispute. So we say there's nothing in that point. Just to be clear, then at paragraph 22 at the bottom, just so you can see the tribunal closed off one matter straight away. Paragraph 22 at the bottom, last sentence, conclude that it would just be just and equitable to extend time so that all the complaints going back to November 2014 could be heard.
I think, in case the contrary might be thought, that by the time we reached closing submissions, the respondent was taking no point. So nobody should criticise them for not explaining what factors they take into account. That was the
point I was just about to make.
Yeah,
there was a conclusion reached, no further reasoning, but it wasn't necessary in circumstances where no point was taken in relation to it. Next significant point that the tribunal deals with is at paragraph 29, and that's credibility. And that is because it devotes 2 paragraphs to credibility, and that is because the respondent put their case very much on the basis of credibility, not solely on credibility, of course, but credibility was a very important matter so far as the respondent was concerned, and so it's dealt with by the tribunal, paragraphs 29 to 30. Last line of paragraph 30 is really all I need to take you to. In our view, considered in that context, what the impact of him on him had been and could be of the matters that the tribunal concerned with. In our view, considered in that context, the claimant's response, his conduct of these proceedings has been measured and his credibility is, in our view, intact. So dealt with the narrative, dealt with the law so far as they needed to, dealt with the easy finding on time limits, and
just say that credibility was relevant, to some of the accounts of some of the primary facts.
yes. And additionally,
But actually on the matters which we're looking at, which are primarily concerned with whether there was less favourable treatment, his credibility was not really material.
it was not not material.
I'm not making a particular point, I'm just getting clear in my head how this
Yes,
fits in. You're perfectly entitled to take this point, but it's actually not central to the issues in front of us.
It's not central to the issues. I mean, I'm just picking up on your observation, though, my lord. We also made the same point below in relation to credibility, in relation to some matters. Plainly, what the claimant thought about what the tribunal were doing and so on at particular times. Sorry, what the GMC were doing at particular times may give rise to issues of credibility, but often, as your lordship's already said, often not. So there was an issue about how far credibility was relevant at all, but nevertheless it was relied on significantly by the respondents and it was dealt with. So, as I've indicated, so far this is a coherent judgment, dealing with the narrative, dealing with the law, dealing with one of the central planks of the respondent's case, and then getting on to what we've described as the list of issues, although I understand your lordship's point there.
No, I wasn't really making a point, I was just checking out looking at the right document. Yep.
As you've your lordship's already identified, there are 4 extant complaints, and just so that I can flag them now: referral to the second IOP, failure to progress the AR allegation against Dr. Laniardo while doing so against the claimant, proceeding with an allegation concerning the AR allegation, though conveying...
You're going a little bit too fast,
Sorry.
Monaghan. As you said, here are the 4 points. Can I write them down?
These are the extant complaints for
Yes.
the purposes of this appeal.
Yes.
So
In one way, to save my lord's pen, they are sent. You're simply reading out effectively what we see above page 30, para 33, above para
Yes.
64. Sorry, I should.
no, that's...
I have underlined them.
Well, there you are then.
But
there you are.
since-
It was intended to give you a simple way in.
Sorry,
unhelpfully.
meant to be helpful, being unhelpful. Do
Not
them
at all.
again at dictation speed.
And I was about to say that although those are the only 4 extant complaints, it is necessary to go through some of the other paragraphs of the judgment, because there are references back and forward to what the tribunal said at particular points. So I will try and do it as efficiently as possible, but I do need to make some observations along the way. So paragraph 35, this is the interim orders panel application in November. No finding of discrimination, of course. Tribunal concludes that at that stage, there's no material difference in the treatment afforded the claimant as compared to Mr. Laniardo, his comparator. This is at a very early stage, before the Hollywood reports. So I flag that because there are references at various stages to there being inconsistencies in the findings of fact. Well, it's important to locate ourselves in terms of chronology. November 14, there are no Hollywood reports. There are only the terms of reference following the Roche report. Paragraph 35, Tribunal emphasises that at this stage of the investigation, paragraph 35, this stage of the investigation, there were concerns and Mr. Laniardo was treated in a similar manner. Last sentence, on this matter in isolation and at this stage, we're unable to draw an inference of discrimination. So no adverse findings, but located very much at the point in time that the tribunal was concerned with there. Second and third issues, next page, page 115, failure to close the investigation after the first IAP and failure to undertake a comprehensive review. Again, these failed at this stage. So if one looks, please, at paragraph, just pausing there, forgive me. Yes, so paragraph 35 refers to the Roche report considered by the registrar and so on. No difference in treatment as between Mr. Laniado and the claimant. Also says at paragraph 37 there wasn't a basis.
Sorry, was that 35 you were reading from? You
36.
36 to 35. Yeah, okay.
And simply observing that no mechanism for closing it at that time, no difference in treatment, so no discrimination. And then...
Well, I'm not saying you're wrong.
But I'm going to...
The structure is 37 is just sending out submissions. Where's the conclusion?
I'm just going to come to that.
Oh,
so
sorry.
I'm flagging that there's no finding of discrimination in relation to this. And if one looks at how the tribunal deal with it, they set out the context at that stage, paragraph 36 to 38, already having identified in the previous paragraphs that they were at an early stage. And then paragraph 39, foreshadowing what's to come, to the extent that the claimant's complaint is that his case should have been closed after first IEP without reference back to the case examiners. Complaint is not well founded, no power to do so. The claimant's complaint properly considered, however, in our view, is that he was treated differently to Mr. Laniado because his case continued, but Mr. Laniado's case was closed. So it is foreshadowing the later complaints, saying at this stage, no discrimination, nothing could be done at that stage. And that's emphasised by paragraph 40, where the tribunals say again, there was a difference in the cases of Mr. L and the claimant that explains the difference in treatment at this stage. Following the Hollywood report, in contrast to the claimant, none of the allegations were considered well-founded. In closing, against considered well-founding, and the respondent's case examiner, in closing his case, noted the Hollywood report found that 4 of the 5 concerns were not supported by the evidence, and respect of the 5th, the trust had decided not to proceed with a disciplinary hearing. So it's looking into the future. Early stage, they have the all they have are the terms of reference for the Hollywood report following the Roche report, referral to the November 2014 IOP, no difference in treatment. Still at an early stage, right after the IOP. Second and third issue, paragraph 36 onwards, no difference in treatment, no facility to close it at that stage, but foreshadowing the later complaints that there was a failure to close the case in relation to the claimant, while there wasn't in relation to Mr. Laniado. My lord, your lordship's looking like you're about to ask me a question.
Well, I mean, up to the end of paragraph 40, in paragraph 40, they're saying that the 2 cases at that stage, anyway, were properly treated as different.
Yes.
Yes.
So paragraph 39, last sentence, they're flagging that the complaint really is that in due course, case continued against the claimant, but not Mr. Laniado. Paragraph 40, they're saying at this stage, of course the GMC hasn't commenced its investigation in any meaningful way. At this stage, what they have are 2 reports, one indicating that there are proven complaints against the claimant and not against Mr. Laniado. So there was a difference in treatment. But in any event, the tribunal have found that at this early stage, there was no basis for undertaking, for closing the investigation or undertaking a comprehensive review. So this early stage, no basis for review or closure. His real complaint, they say at paragraph 39, is the case continued against Mr. Laniardo. Noting, however, at this stage, there were differences in their cases. So what the tribunal are doing is plotting through what was happening at various stages. So, as I've indicated, nothing at the November IOP except the terms of reference, which your lordships and your ladyship haven't seen yet. No difference in treatments. No reason after the IOP, still no investigation reports or anything of that sort immediately afterwards. No basis for closing it or seeking a review. Flags the fact that what the claimant is really complaining about is that the complaint proceeded against Mr. Laniardo and not him, but noting too at this stage, once the reports did come, there was on their face a difference in the findings, so a difference in this situation. May I track it through, and I hope that I will convince you that it makes some sense in the face of some expressions indicating that may not be, that may take some effort.
I just find paragraph 40 and paragraph 47 difficult to line up on the side one another. Anyway, you haven't got to 47 yet.
I haven't got to 47, and we are now, when we get to 47, we are now at February 2015.
Yeah.
So if one looks at the bottom of page 115, we see the next issue, as I'm describing them. And we're now at 2005 and 2015, forgive me, 2015. And there is a decision to make a second referral. Of course, the GMC are now properly seized of the complaints. They have the Hollywood reports. They can see what they say. It's their obligation to investigate those complaints. Just let me make sure I don't lose my page number. Just bear with me. I've taken myself ahead of myself. Just bear with me, please. Yes, because I was going to take you to some documents, but I'll just skip over those. Yes, perhaps I could just flag, and then I'll come back to it when the documents arrive, just flag that in relation to the complaints identified in the Hollywood reports, although there were no positive findings against Mr. Laniardo, 2 of the complaints corresponded with 2 made against the claimant, including the MDT complaint, which was not decided in favour of Mr. Laniardo, but was let open. So
well, I think I'm finding that a little difficult to follow with that. Is the Hollywood report in the missing documents bundle? Well, we can come back to it when we get it. I'll just flag up there's a point you want to make about it without trying to understand what that point is. If it's crucial, we will rise and see if we can get hold of it now. But
I wonder if it's just making my job harder.
No, well, we don't want to do that.
In the face of a decision that may...
No, I agree. We really don't want you to be prejudiced by this administrative error. Well, I think the sensible course would probably be to rise. How many? We've lost our copy of the bundle, so I can't now see how many pages are there in it. If we had to individually
150
print.
something.
Sorry?
150, something like that.
211.
211.
So it would be tiresome, but not impossible for us to print it, or it might be enough, as I say, for us to simply, if we can check that it's available on online, we can follow it in that way. What?
If they can't find it, they were going to print it.
I see. I'm being. My lady spoke to my clerk last, and I think her plan was actually to print it if they couldn't find it.
Oh.
So we may actually get it quite soon. Yeah.
Can I just ask, looking at their paragraph 40, the respondent's case examiners, in closing Mr. Laniardo's case, noted the Hollywood report had found that 4 of the 5 concerns were not supported by the evidence. In respect of the 5th concern, the trust had decided not to proceed with the disciplinary hearing. Is that the one that you're talking about?
That is the MDT one, yes.
Yes.
And in fact, it was also not proceeded with by the GMC, though of course it was with
Yes.
the claimant. There were 2, in fact, extant complaints against the comparator, neither of which went anywhere, so far as he was concerned.
I think for the moment, if you get into serious difficulties, we will have to rise and get the documents. For the moment, I think it doesn't prejudice you if we simply flag the point you're making about para 41, and we can come back to it when we get the documents. But let's carry on the exercise during the moment, which I must say I'm finding helpful.
Just before we move on, sorry,
Yeah.
is that right? Just back, you said there was 2 complaints that overlap.
Yes.
As I think I read it before I got the paper, one of those was one of the ones that was found not to be supported by evidence, so it went, but altogether. But the other one is the one where they decided not to do anything about it.
Well, there were two overlaps.
Yes.
Ultimately, there was the MDT,
Yes.
and there was the canteen
Yes.
complaint. And in relation to the canteen complaint, Ms. Hollywood found it wasn't substantiated.
Yes, that's what I thought.
Of course, that doesn't obviate the need for an investigation by the GMC.
Well, let's just try and stick to the differences at the minute.
And then the second one was the MDT.
Yep.
So those were the overlaps.
All I was wanting to clarify in my mind, that of the 2 overlaps, one was potentially provable, but a decision was made not to proceed.
Yes.
The other one, it was decided that it was not supported by the evidence.
Yes.
Thank you.
Yes. That's fine. Yes. My junior's reminding me. I shouldn't say my junior now. My co-leader is reminding me, but I'm sure your ladyship's picked this up, that it was the complaint was that Mr. Rao was relied upon for the purposes of the complaint against the claimant, but not Mr. Laniardo when he was regarded as incredible. So that's one of the concerns that the tribunal had insofar as the GMC's response was concerned.
Yep. Thank you.
So you'd like me to continue?
Yes,
Right. So as I've indicated, paragraph 40, that stage, there was a difference between the cases.
So which para are you quoting on?
I'm just rolling up paragraph 40.
I
So
thought we'd
paragraph
been there,
39, they foreshadowed what's going to happen later. That is, the real complaint is nothing happened to Mr. Laniardo in due course, but the claimant's case was not closed. Paragraph 40, it acknowledges that there is a different, the circumstances are different at that stage, in that there are, of course, different outcomes so far as the Hollywood complaints are concerned. As to the second referral then, the first complaint, so starting at paragraph 41, you'll have spotted that conditions were imposed, which is, of course, very significant for a doctor, as you might imagine. You saw that at the bottom of paragraph 41. paragraph 42, addressing the case put by the respondent, that is that there could be no discrimination. They ought not to draw an inference of discrimination in circumstances where the claimant could have gone to the High Court, dealt with that. Plainly, that doesn't mean there can't be discrimination. And then at paragraph 43, they are picking up now what happens going forward. That is that following the report, Mr. Laniado's case was closed by the respondents.
Very helpfully, thank you. The associate has checked that the bundles are being copied now, so we should have them as long as it takes, but it shouldn't take that long. Sorry, I interrupted you.
Not at all. I'm just trying to find my note because I'm skipping through evidence references, and I don't.
Are these references that you would have wanted to take us to now, or not necessarily?
I can leave it. I can come back to them, but just if I can just draw out some points.
Yes,
in determining whether or not this was an act of less favourable treatment, that there was some difference in treatment. Tribunal noted at paragraph 43, following the publication of the report.
Sorry, can I just make one point while I've just, if you look at para 42, where they set out the respondent's case, and you said there wasn't much in that point.
Could you give me the paragraph number?
Yes, para 42. The claimant says X. The respondent, on the other hand, says it's difficult to understand how this can be a particular discrimination when the IOP made an order, and so on. Yeah.
Yep.
If you actually look at the respondent's written submissions, closing submissions, supplementary bundle 72. You see that point appears as para 84, but there's another paragraph at 85 addressing the substance of the point. So 84 is making, as it were, an overarching point about how can this be discrimination at all. 85 is then addressing the substance. That 85 doesn't appear to be reproduced in paragraph 42, where the tribunal is setting out what the respondent's case is on this point.
No, but the point that's being made at paragraph 85 in the submissions is that Mr. Laniado couldn't have been a proper comparator because of the difference in number and so on of the allegations made against him. And the comparator point is dealt with by the tribunal.
I see. Here they are.
I have 2 copies. The third is almost complete.
Oh,
So
right.
I'll bring them in anyway.
Thank you very much indeed. We've got, well,
And I have Council's copy.
well, there's a third one coming. May we use Council's copy? It's not.
No, it's not Council's copy. I
disadvantaging
think
you.
it's a clean copy from my instructing solicitor.
Very well. You can have it back when the third one arrives. Thank you very much. Right. Well, we are where we should be. Up to you whether you immediately take us to the references you've skipped, or whether you'd like to do that later. Now.
Why don't I just introduce Hollywood? So
Yes,
your,
certainly.
Lordships and
Now I
your ladies.
realise that my complete frustration yesterday at not having the Hollywood reports was not well founded. They were there.
Yes, so if I can ask you please to take up the respondent's supplementary bundle. And it's divided helpfully into 2 parts. Section A concerns the claimant, Section B, Mr. Laniado. And if, please, you could turn to page 4. That's the report delivered to the GMC and the Trust December 2014, so after the date of the first IOP. And your Lordships can see at page 6 the terms of reference. So before December 2014, what the GMC had was the Roche report and the terms of reference. In other words, the concerns that had emerged from the Roche report and that needed to be investigated. Terms of reference, you see at page 6, threaten, verbally abuse Mr. Rao, influenced the MDT, benefited financially, and sought to interfere with Mr. Robinson's evidence. And then at page 7, dealing with them in turn, whether Mr. Karim verbally abused and or intimidated Mr. Rao at a meeting, finds at page 9, above the shaded box, clear that an inappropriate and inflammatory conversation was instigated by by Mr. Karim during what purported to be a business meeting, and this could reasonably be perceived by Mr. Rao's victimisation linked to him raising a concern. By his own admission, the claimant's decision to raise the matter was linked to his belief that Mr. Rao tried to damage him by writing the anonymous letter. In my view, it would be reasonable to conclude that the claimant raised the matter of repaying fees for punitive purposes linked to Mr. Rao raising a concern. So,
I'm so sorry to interrupt. It's not him, it's HM, which is Dr. Motawala.
forgive me.
Yeah.
Online file.
Sorry, I beg your pardon. HM. Hayard tried to damage HM, Dr. Motawala, thank you, by writing the anonymous letter. So that was the finding. And then the MDT, next shaded box, findings in relation to that set out at page 11. And bottom paragraph summarises the conclusions. Having considered all the evidence, it's difficult to conceive of the claimant's actions in creating the letter as anything other than an attempt to provide cover for Mr. Motawala's error. That is, was it urethral, was it penile? No need for the claimant to involve himself in this matter at all, did so voluntarily for reasons of personal loyalty to Mr. Motawala. There's an argument to say that in producing and circulating the letter for signature, the letter, and irrespective of whether or not it was ever sent, abused the trust of his colleagues by enlisting their inadvertent support for a misleading statement intended to conceal the error. It's unclear what that's intended to refer to, since those who signed the letter were assumed to understand what they were signing. Over the page at page 12.
Well, I mean, we're not going to go through it now, but presumably when we later read the evidence in support of that finding, we'll find out why they say it was inadvertent support or the factual basis for them reaching that conclusion.
You won't have that evidence, but what you'll have are some of the documents produced by the GMC identifying what they made of that.
Thank you.
So paragraph, page 12, the next shaded box, whether the claimant has benefited financially by manipulating the work of the department. That's not upheld. So if one looks at the bottom of page 12...
We've now got the final copy.
And I've now written on this.
Yes, so whoever...
We don't.
You don't want it. We copied it especially for you.
Can go back to the solicitors.
Can go back to whoever lost it in the first place.
Thank you very much. Thank you. So bottom of page 12 are the findings in relation to manipulating the work of the department. Comments suggest that the management of the general urology workload should be subject to an investigation. In view of the ongoing dispute about the scope of practice and access to robotic surgery, it would seem sensible to review all aspects of provision of the service to the local population and if necessary adjust job plans. I was concerned to note by reference to Appendix 36 that some of the claimant's patients appeared to be added to the cancer register after having their surgery. Trust might want to satisfy itself that patients, including tertiary referrals, are recorded appropriately. So no finding, and there hasn't been since, so there wasn't thereafter, of any suggestion of manipulating the work so that the claimant, or indeed others, could help sustain a private practice. And then if I can ask you please to turn to the report of, just bear with me, the next allegation, page 13, and this is Mr. Robinson's complaint, or the Mr. Robinson complaint, I'll call it. You'll see just next to the first bullet hole, letter states his account. Mr. Robinson has written an account of the conversation with the claimant, states that he felt intimidated to withdraw his statement to the GMC, the GMC investigation into Mr. Motawala. When interviewed, he expanded on the context of the conversation, saying that he'd been approached by the GMC after his name was put forward as a witness in Dr. Charrick's complaint about Mr. Motawala. Mr. Robinson intended to be transparent with his senior consultant colleagues by telling them of his intention to provide a statement in relation to the matter. Mr. Robinson told Mr. Motawala and Mr. Laniardo about the statement, and Mr. Robinson, when he explained the situation, Mr. Motawala was understanding, didn't challenge it, and Mr. Robinson made no complaint about Mr. Motawala or Mr. Laniardo's response. He then, or at some point, telephoned the claimant, asked to meet with him to discuss face-to-face matters. He said his purpose, as with the other consultant, was to explain the circumstances in which he was giving a statement about Mr. Motawala. Claimant met Mr. Robinson next day, and in contrast to Mr. Motawala and Mr. Laniardo, Mr. Robinson said that the claimant expressed the view that Mr. Robinson owed Mr. Motawala loyalty because he'd been shown loyalty in the past when job security was under threat and so on. Mr. Robinson said the claimant's view was that he should withdraw the statement to the GMC, and Mr. Robinson said that caused him to reflect on his statement over the next few days, and he chickened out, deciding he couldn't legitimately contribute. That was upheld by way of a discipline, by way of a finding. Page 14. Clear that Mr. Robinson was doing no more than complying with his duty as a doctor by providing a statement, and so on. Appears to have taken it on himself to sow doubt in the mind of Mr. Robinson as a pawn, by suggesting he might be a pawn, suggests that there is complaints or allegations well founded. So those are the allegations in relation to the claimant.
But just from the point of view of when we're starting to look at the comparators again, the account of Mr. Karim's conversation lacked credibility as that its
I beg your pardon, my lady, I couldn't hear you.
Oh, I'm so sorry.
It's okay, you're looking...
I was just looking at the totality of the findings.
So
I think we need to read the totality of the findings in that respect for when we come on to the comparator.
My lady. So so your ladyship was...
It was just the second paragraph of the findings made a finding of credibility so far as your lay client is concerned, which may or may not reflect on the comparator in due course, given what's said in the final paragraph.
My lady.
No, darling.
I did. Yes. There's certainly no dispute on our part that there was a difference in the nature of the allegations, the particular allegations. I mean, Simon Robinson, for example, wasn't the subject of any complaint in relation to Mr. Laniardo. There is certainly a difference. The question is whether or not Mr. Laniardo can be a comparator for certain purposes the fact that there were 2 allegations, just to flag my submissions, 2 allegations which the GMC ought to have been investigating in the same way, that is, Mr. Rao and MDT, those are matters that the claimant in my submission can rely upon for the purposes of establishing a comparison. It's not necessary that all the circumstances be the same, and it's also, a claimant is entitled in my submission to say, well, okay, they may have done that okay, but that doesn't justify them pursuing these 2 allegations against me. And that's important as well because the weight of the allegations varies. So, for example, as I indicated earlier on, the Dr. Hayter allegation was regarded as something that wasn't terribly serious in due course. And so my submission can't wrap them all up together and say, well, because wrapped up all together, there were a greater number, that means one can't make any comparison. It's the claimant's case that 2 were clearly live against Mr. Laniado and against the claimant, and Mr. Laniado was closed down and the claimant was pursued. And in my submission, that comparison is permissible, and to wrap them all up would also obscure the fact that, of course, MDT in particular, but also Rao, were very serious allegations. The fact that there were other allegations on the margins might be understating their significance, but nevertheless, they were distinct from these. Can't be deprived of the opportunity to compare oneself in relation to 2 allegations because there happen to be others too, in my submission.
Are you going to take us to what Ms. Hollywood found in respect of Laniado?
I'm going to do that just this minute. Thank you. So if your Lordships and your Ladyship now please turn to the same bundle, page 87. And I can ask you please then to start at page 89. You'll see, just a flag, the terms of reference, same form adopted here. Roche reports and terms of reference are then drawn up for a disciplinary investigation. So the terms of reference at page 89, drawn up before the investigation reports. And as with the claimant, this report's December 2014. And the overlapping complaint, page 90, intimidated Mr. Rao. And you'll see under the shaded box, Mr. Rao's evidence, concern was described in his document, Intimidation and Threats from Mr. Karim, which provides Mr. Rao's account of events on the morning and the perception that he was ambushed by the claimant and Mr. Laniado during a meeting ostensibly convened to discuss the scope of practice. I can take you all through it. I propose to go to the three paragraphs up from the bottom, just to record what Mr. Rao said, but not meaning to leap over anything that your Lordships or your Ladyship may think significant at this point. Because we see there, penultimate paragraph from the bottom, the allegation made by Mr. Rao in respect of Mr. Laniado, apart from the ambushing. He says, Mark then attacked me, saying he gave up sessions to accommodate me. He went on to say that he does not claim his time for being the surgical tutor. Goes on to say that Omar, the claimant, and Hanif Motawala have also given up sessions to accommodate me. Mentions they all have a taken a pay cut to accommodate me. I'm made to feel guilty. I'm again made to feel guilty, as though I have to be a slave and listen and do whatever they want, rather than what I'm supposed to do. So, complaint of ambushing and attacking, so far as Mr. Laniardo is concerned. Again, I'm not meaning to leap over anything that your lordships or your ladyship may think material. I propose to take you to how, to the findings and how Ms. Hollywood addressed the evidence of Mr. Rao. So at page 92, at the top, clear that an inappropriate and inflammatory conversation was instigated by the claimant during what was purportedly a business meeting, and that that Mr. Rao could reasonably perceive this as victimisation, linked to him raising a concern, sets out the bullying and harassment policy. Next paragraph, Mr. Laniardo's evidence suggests he discharged his duty in this respect by telling, that is, stopping the bullying, by telling the claimant and Mr. Motawala that he felt the claimant's comments in the meetings were inappropriate and unhelpful. Mr. Rao acknowledged that Mr. Laniardo and Mr. Motawala were apologetic. Then goes on to Mr. Rao's evidence. Mr. Rao's evidence suggests that any objection he held to Mr. Laniardo's own reported comments during the meeting about giving up the sessions to create a new consultant post was not considered to be of sufficient concern to him at the time to merit a mention in his email to Mr. Laniardo the same day. So in other words, casting doubt on Mr. Rao's credibility. Really, if this was as serious as you said it was, why didn't you refer to it in the email to Mr. Laniardo? Similarly, in respect of the messages appended, Mr. Rao's...
Well, you've left out a quite important sentence. In my view, to later report these comments as an attack by Mr. Laniardo is not credible.
I thought I said credibility.
Well, sorry,
but
perhaps
yes.
you had. Yeah.
No, that's my fault.
Okay, don't worry, we're dropping that.
Precisely. So, and that's an important, as your lordships plainly identified already, an important concern for the claimant. That Mr. Rao's evidence is treated as lacking credibility in relation to Mr. Laniardo, but not so in relation to the claimant. Well,
are you saying that an investigating officer can't prefer the evidence of one to the other?
An investigating officer can, certainly, but insofar as the GMC are concerned, when they are seized of an investigation, they have complaints against Mr. Laniardo and Mr. Karim, the claimants, concerning the same matters. And when the GMC are looking at this, what they can see is that credibility is assumed in the case of the claimant, but not in the case of...
Well, it's not quite as simple as that, is it? I mean, it looks as though what Ms. Hollywood did was accepted Mr. Rao's general picture of an inappropriate conversation having taken place, instigated by Mr. Karim, but didn't accept his later characterization of some of the things said. There's no inconsistency there. You can believe a witness is credible in the overall picture, but not as to some of the particulars. That's quite a common situation.
Well, of course.
And that appears to be what Ms. Hollywood is distinguishing between the parts of the evidence which were particularly relevant to the complaint against Mr. Karim and the parts that were more relevant to the complaint against Mr. Laniardo.
What we're concerned with here, though, is what the GMC did with that material.
Well, I dare say, but...
The GMC was seized of those allegations. It's their job then to investigate whether those allegations are made out and may found a charge of misconduct. They don't defer to the trust in determining whether or not misconduct is or may be made out. They conduct.
Well, they may or may not, but the I don't know what tourism is deferring. Surely, the GMC in deciding how to proceed, this is the principal material they have.
Yes, and they then could.
Why? I'm not quite sure what your submission is. Are you saying the GMC looking at this, at how Miss Hollywood, looking at Miss Hollywood's findings, were bound to not accept her findings about Mr. Karim if they accepted her findings on Mr. Laniardo?
No, but I do say that that when the GMC come to review it.
But this is the GMC, isn't it? Or?
So no, this is Hollywood. This is
No, I know. So what I was putting to you was, when the GMC come to review it, weren't they entitled to read Ms. Hollywood as having made different findings about Mr. Karim and Mr. Laniardo? Nothing you've shown us here suggests that there was something odd about why they thought there was something to complain, something to investigate for in Mr. Karim's case, but not in Mr. Laniardo's. On the contrary, the findings are different in the two cases. I may be misunderstanding the purpose for which you're taking us.
I'm going to take you to a document. Perhaps I can articulate it better.
Okay.
By reference to that. But let me just make
the
the short point. I perhaps can't make it any better, but the short point is the GMC are reviewing whether any of the allegations in the terms of reference identified in the Hollywood report are sufficient to, any of the allegations are sufficient to found a need to further investigate, to charge ultimately, and so on. And in undertaking that exercise, it's the duty of the GMC to look afresh at the allegations. Plainly, they can rely on the evidence collected, but it's to look afresh at the allegations. And one of the matters that emerged during the inquiries was that, in part, Mr. Rao had proved to lack credibility. Not on everything. May I just take you now to a document, my lord? Because it's in the Appellant's unagreed supplementary bundle, I think we've now called it.
Yep.
If your lordship turns, please, to page 80. This is a document that is dated May 17. It's not the face of the document, but it's May 17. And it's
May 17, which
2017.
Yeah.
And it is what it says. It's an analysis of allegations and advice on the realistic prospect test. So before the charges can be formulated,
And who created this?
it will be the investigator.
Do we have a name?
No, it's not the
The
investigator.
case examiner.
No, it's not. It's the legal advisor to the
Oh,
investigation.
oh.
That's why it said a legal commentary
Okay.
on the right-hand side.
Perfect. So there's the so it's the legal advisor then analysing the allegations to determine whether or not any of them are likely to satisfy the realistic prospect test, and that, no doubt, you'll understand, must be a reasonable prospect if it's going to be subject of a charge. And so we see the first allegation, whether the claimant benefited financially, says no evidence to support this allegation, therefore doesn't meet the RPT. They're just pausing there. Ms. Hollywood had already said that, but nevertheless it's their duty to make a finding themselves. And then the next one, 16th of January, verbally threatened Mr. Rao, cites the materials that it has, says, I've added an allegation in relation to this incident. However, I would advise the prospect of meeting the RPT is relatively small in light of the fact that the main witness is not a credible witness and so hasn't been approached for a statement. So when we're looking at credibility, we're starting from a position that Ms. Hollywood has identified credibility issues in relation to Mr. Rao. The complaint is nevertheless, or the allegation is nevertheless, pursued as against the claimant, but drawn to a summary close so far as Mr. Laniardo is concerned. with no consideration of the credibility that was plainly apparent early on. And at bottom paragraph in that box, I'm therefore of the view it's unlikely to meet the RPT, but have included it for completeness at this stage. We would need specific statements from Mark Laniardo and Mr. Kelsey to provide some form of support to this. Might be pragmatic to put the allegation to the claimant to see a response and then quickly seek statements if necessary. That did go forward.
Is RPT reasonable
prospect test? So it's...
Thank you. When was the case against Dr. Laniardo closed?
Was in
November
2015, and you do have that document as well. November 15, and I did propose to take you to that as well.
Well,
Not at the moment.
take us when you're ready. But we'll make
Anyway, so you have the short point. There's a difference, we say, so far as credibility is concerned. I don't say for a moment Ms. Hollywood can't make different findings, given that there are different witnesses. But credibility is raised at an issue at an early stage, and we say that was something that GMC ought to have been mindful of.
So just when we're looking at page 81, following down your box, two potential GMC witnesses are not overly detailed on what took place nor how Mr. Karim approached the discussion. Further out, those two witnesses want to actually state that this hostile flaw is himself problematic. Now, the second of those two witnesses, I think, must be, reading the next paragraph, must be Mr. Laniardo. Because it says we'd need specific statements from Mr. Laniardo. So that looks like your legal advisor is accepting the Hollywood finding as to Mr. Laniardo's role and credibility for the purposes of his assessment of this. But please correct me if I'm...
No, I think that's
That
yes.
sounds like it works.
Yes,
Yeah.
yes. Can I take you back to Mr. Laniardo's Hollywood report, if your ladyship and your lordships have that? And we see at page 93, top of the page, whether Mr. Laniardo, with inclusion with others or otherwise, made misleading recommendations, no findings in relation to that, and we needn't trouble ourselves with it. Page 94. Shaded box 5.3, neglected duty, no adverse finding, and doesn't concern us. And whether Mr. Laniardo has benefited by manipulating the work of the department and private practice and so on, again, not upheld. And page 97, bottom of that section, that is still on the manipulating the work, comments at appendix 3 and so on, makes the same observations that it did in relation to the claimant. That is, there's a wider review going on about the distribution of work. And then 5.5, interfering with previous investigations. And there are two. At page 98, the first is CJ's evidence, or the CJ investigation. If I can actually start further below and look at ML's evidence, because it then sets it out.
Sorry, you've lost me.
Sorry, I beg your pardon. Page 98.
Thank you.
Page 98. So we're looking at the materials under the shaded box, whether alone or collusion with others, sought to interfere with other investigations. And 98, under ML's evidence, just between the two bullet holes, one is the MDT letter. In the interview with Mr. Laniardo, he said that he couldn't remember the details of whether or not he'd signed it, subsequently agreed he had signed the letter, said this was predominantly to agree the cancer was urethral and not penile. This view was based on a second report from Dr. Freeman, and cited problems with the lack of MDT coordinators, and said he'd signed the letter in the belief that the case had been discussed. That's that. And then the CJ investigation.
Who was CJ?
I don't know her name. Caroline Johnson.
Thank you very much.
She was somebody who it was understood Mr. Motawala had pushed or poked, and Mr. Laniardo was said to have given evidence in relation to that. I'll just come to it. So there's two. Covering up, one is the MDT letter. Two, denied telling Mr. Rao he'd lied to the investigation about what he'd witnessed, that is whether he'd seen the push or the poke. He agreed that he feels a sense of personal loyalty towards Mr. Motawala, but said this wouldn't extend to providing false testimony and lying for him. In respect of whether or not he could have witnessed Mr. Motawala prodding CJ in the shoulder, CJ's confirmed that I was working on the computer at the time. In any event, findings, these matters aren't determined, finally. So, findings, MDT letter, said he signed the letter because he felt pressured to sign or be singled out by the claimant. Another, Mr. Kelsey, declined to sign. Mr. Laniardo signed the letter and said he agreed with its contents based on the information he'd seen. External clinical opinions suggest, at least to a consultant urologist, it should have been obvious that the patient's cancer was penile. So pausing there, at that point in the Hollywood investigation, it's understood that the cancer was penile. Turns out to be urethral. So, my Lord, so I see your ladyship has the point. I was mindful of my Lord Justice Bean looking like I'd lost him, but
No, I lost the place.
Probably lost you a long time ago. But in any event, the point is, at the time the Hollywood reports were being prepared, it was understood that the letter stating that the cancer was urethral was incorrect because it was penile, and that the experts indicated it was penile. The Hollywood is saying to the case manager, might wish to consider the extent to which he's satisfied, that's the trust case manager presumably, might wish to consider to the extent to which he's satisfied ML acted in good faith in adding his signature to the MDT letter in view of the external clinical opinions that this was a penile cancer. Was there a lack of good faith? And then the CJ investigation.
Sorry, lack of good faith by who?
Mr. Laniardo, in signing a letter he knew to be untrue.
Oh, I see.
Well, except he said he believed it to be true, and it turned out it was true.
Yes, exactly the same as the claimant.
Well, I'm looking at...
Yeah.
So
both of them signed, the claimant drafted a letter that many consultants signed, saying this was urethral cancer, and it was discussed at the MDT. Hollywood's experts, or the trust's experts, said no, it was penile, and the contents of that letter were untrue, and they were written to cover up for Mr. Motawala, who didn't put it to the MDT, didn't follow it through the right pathway. It transpires that it was urethral, but that matter pursued as against the claimant.
Did it go to the MDT?
No, but not until it's decided not to in September 2017, I think. I beg your pardon. Mr. Jupp thinks I've misunderstood your ladyship's question. As I understood the question, you were asking me, did the MDT go to the MPT as an issue of misconduct, a matter of misconduct?
No. Did it ever?
I did misunderstand it then.
Sorry.
No, my fault.
Muttering again. Did it? So we know it was urethral, not penile. but had it in fact been to a multidisciplinary tribunal hearing? I don't mean
So, no, yes, it had. Well, certainly there was no suggestion it hadn't. The final conclusions indicated that it had gone to the MDT. Didn't seem to be any dissent about that finally, and it was urethral. So there was nothing improper in the letter, but it was pursued in the case of the claimant until September 2017, and it was brought to a summary conclusion so far as Mr. Laniardo was concerned. So those are the Hollywood reports. They are different findings, and I've not sought to hide behind the fact that there are more numerous adverse findings and so on, but I flagged the points I do. 2 of them overlapped. Credibility issues arose, as the GMC well knew and acknowledged in 2017 in relation to Mr. Rao, and the MDT matter disappeared early on when it was discovered it was urethral, and there was nothing to see there, so to speak. Mr. Jupp suggests I take you back to the bundle to look at page 99.
Which bundle is this?
It's the one we were just looking at with the Hollywood report in it.
Yep, I still have it open, it happens.
And to Mr. Jupp's inviting me to draw your attention to the fact that in relation to the CJ investigation or allegation, you'll see that page 99, 2, CJ investigation, you'll see at the second paragraph, respective positions of ML and CJ appear to be irreconcilable. In my view, the matter has now become one of credibility, and given the seriousness of the concern, which is a probity issue. So expressing concern about good faith, bad faith, and probity, and we say...
This is in the context of whether or not he lied about having seen Mr. Motiwala, or not having seen Mr. Motiwala prodding Miss Johnson.
You raised your eyebrows, my lord. Is that something I should draw from that? No.
No.
Sorry, my mistake. I thought...
Well, I certainly wasn't. I mean, I may have involuntarily. I suppose my thinking was that, and I'm not sure. I wouldn't put this point to you unless you spotted something. The allegation does not appear. We don't know much about the allegation, but it doesn't appear to have been of enormous significance. I mean, there are prods and prods, but it doesn't look as though it was an enormously important allegation. The probity issue is merely how Miss Hollywood characterised the fact that he said he hadn't seen it,
Yes.
and there was some reason to believe that he would have seen it, though it's not quite clear whether Miss Johnson is the position that Miss Johnson said that he had seen it. I'm not sure how she would know that he had seen it.
Well, I think my recollection of the documents is I think it said the position Mr. Laniardo was in was such that he could not have not seen it.
Yes, I see.
And that he was covering up from Mr. Motiwala.
Yes, well, I see that. Well, clearly we mustn't lose ourselves, and you're not attempting to lose us in the details of these allegations. We're simply looking at the material to see whether, effectively, the difference of the treatment of Mr. Laniardo from that of Mr. Karim is so surprising as regards the various allegations made that it's reasonable to infer that it's possible to draw an inference of racial discrimination.
Well, my lord, in my submission, I would say to your lordship, the threshold you've just identified is set too high. It doesn't need to be surprising. One may be.
If I said surprising,
I think you said that one's looking at it to see whether or not the difference is so surprising that one could draw an inference of race. And in my submission, that sets the threshold too high, but it perhaps is just a matter of.
How would you put it?
I would say that the difference in treatment is such that having regard to the broader circumstances and the difference in race, you can draw an inference of race. That requires something more, as your lordships and your ladyship know, than a difference in treatment and a difference in race. But it doesn't require anything surprising. It's a judgment that's made in a contextual.
What do you mean by the broader circumstance?
Well, the broader circumstances here I'll come to, but there are things like the dropping of the allegations against Mr. Laniardo, the persistence that they demonstrate in seeking out allegations against the claimant, and then, of course, all the other background evidence the tribunal rely upon at the invitation of the claimant, properly addressed in submissions, such as equal opportunities training policies and statistical material. So the short point, taken rather longer than I'd anticipated, forgive me, is that there were two allegations the same. Tribunal's entitled to take those into account and look at what happened with the claimant and Mr. Laniardo. That's the short point. And we see, though, there is a difference in the number of allegations. Two of them are.
I actually slightly misstated the issue, because the issue is not so much whether there was such material, but whether the Employment Tribunal gave adequate reasons for its apparent conclusion that there was. That's ultimately what this appeal is about.
Adequate reasons.
But it's not only adequate reasons, but on this particular point,
Yes.
it's about adequate
Yes.
reasons.
Yes. And we say the reasons are good enough, as your lordships and your ladyship will have seen from the skeleton argument and the submissions.
Right, we jumped off, not perfectly profitably, but we did jump off from going through the Employment Tribunal, and we're on page 116. I think.
So we will look
this is where we would expect to find these points that we have been looking at discussed.
Yes, and so we see, well, they've already been discussed in part in the previous paragraphs. And then, so looking at paragraph 42, that's the introduction to the dispute, if you like, on the first complaint, the
Yes.
IOP.
This sets out the parties' two positions.
Yep. And then following the report, Mr. L's case was closed by the respondent. Two of the allegations faced by Mr. L and the claimant were the same. I'll come to the closure document so you can see what the GMC said. In the case
Sorry, but did that mean that's what B764 and G16 is it?
I think so. We've kept our original numbers on the.
Well, I think just I mean this is an important part of the case. I think at some point, not necessarily now, could Mr. Jupp or Mr. Hare just identify for us what those documents were. If we got them in our supplementary bundle, so much the better. We ought to at least know what they are.
Yeah, it's,
okay.
I will do a cross-reference.
Yeah. Well, don't worry now.
We've kept our
come back to it
bundle
later.
Numbers, but unfortunately the respondents.
Well, don't worry. Come back to it later.
So we see there. I'll come back to the document, and I will double check that it's the right one, but I'm fairly confident. Paragraph 43. So closed by the respondents, whilst two of the allegations being the same, threatening Mr. Rao not considered well-founded, while the same allegation against the claimant was considered well-founded. So that's the Hollywood report. Decision to refer the claimant to the second IOP. Difference in the way the claimant was treated in comparison to Mr. Laniado. Unlike the claimant, largely exonerated Mr. Laniado, making only one adverse finding, the MDT. In Mr. L's case, the examiner concluded there was not a realistic prospect of required standard of proof. So dealing with Rao, and then dealing with it at 43, then dealing with MDT at 44 and 45. So not pursued Rao, and not pursued MDT, although as the tribunal note, that allegation was sufficiently serious to warrant being put before the first IOP, and plainly it is a serious allegation.
Hang on 1 second. I mean, the flow of thought in paragraph 44 is very difficult to follow, isn't it? It says there was a difference in the way that he was treated in comparison to Mr. L. That looks like a finding of difference of treatment. But the rest of the paragraph appears to show that their circumstances were different.
Paragraph 44.
Yeah.
That the difference in treatment was justified. That's how I read it.
Yes. This really comes to the same thing. Either they were materially different, so the different, or the difference in treatment was justified. Namely, the Hollywood report. I mean, am I not right in thinking about?
Well,
the first sentence of 44 suggests difference of treatment.
Yep.
The remainder suggests that the difference of treatment is accounted for by the fact that there was a material difference between their cases, namely that the Hollywood report made different findings about them.
Not in my submission. In my submission, that's just part of the factual context. So the tribunal is saying there's a difference in the way that they were treated as compared to each other, giving the history. There was largely
well, that's what the first sentence says. But what are the next two and three?
Well,
second and third sentences say?
Sentence sets out the factual context. There was largely exoneration, and then says in Mr. L's case, the case examiner concluded there was not a realistic prospect of establishing the required standard of proof. But that sentence doesn't hinge on the prior sentence, because of course, as I endeavoured to show you when I looked at the RPT document, the GMC is making a decision itself. So it is simply at paragraph 44, the tribunal is saying there's a difference in treatment. Yes, there was this largely exonerating and so on. But in Mr. L's case, in relation to the same allegations, or materially the same, there was the case examiner concluded there was not a realistic prospect of success. Compare the claimant.
And which is the... Have we seen the document containing the case examiner's decisions?
I was going to take you to the one closing the case against Mr. Laniado, because that gives you a...
Yeah, well, that's the one being referred to here, isn't
Yes. So if I can just pause there and take you through these tribunal paragraphs and then take you to that document, hopefully that might be, I hope, a convenient way to deal with it. So we've got the row, and then noting that closed against L in relation to NDT, and you'll read paragraph 45, I won't read it to you.
Yeah.
And then at paragraph 46, you'll see signed by a number of others. And in those circumstances, notwithstanding that, the allegation was pursued against the claimant until 2017.
Okay, thank you.
And may I just take you to the closure document? I'm very conscious of time, which is means I'm not dealing with it very efficiently. I'll try and get through it much more quickly. But if I can just take you to the closure documents for Mr. Laniado, that is at the Respondent's supplementary bundle.
Yep.
Sorry, which page?
It is at page 125. It commences at 120. I'll just perhaps start there. Page 120. This is the case examiner's reasoning. And you'll see it's dated November 15.
It says case examiners, that's plural. There were individual case examiners, presumably.
Yes, and I think there's one lay and one clinical.
Do they have names?
No. And so you'll see the page 120.
Yes.
Sorry, I'm just distracted behind me. The top entry decision, GMC have investigated concerns about the conduct of Mr. Laniado, a consultant at the Trust. Case examiners have determined that the case should be concluded with no further action. Explain our reasoning. And then, 121, second substantive paragraph. We have carefully reviewed the evidence in the case, which includes an external investigation commissioned by the Trust into allegations of poor behaviour, along with evidence gathered during that investigation and the MHPS report and evidence gathered during it. So that's what they've decided to consider. They then deal with the MD...
Is the MHPS report, is that the Hollywood report?
It's the... Yes, it's... I've got to stand to now. Maintaining...
No, I know.
Maintaining
I know what MHPS is. I was just wondering whether whether.
Yes, it was. And then at 121, the bottom, the first underlined text, alleged that Mr. Laniado signed the letter. And then over the page, second paragraph, I won't read it out to you, you've seen this, but the explanation, his belief. And
So you're asking us to read the whole one?
Well, page 122.
Yes, but which bit of it are you asking us to read?
I'm just pointing out the second paragraph.
Yep.
Records what you've already read.
Yeah.
That is, he signed it with the belief, he says the genuine belief that it had been discussed and so on. And the last sentence of that paragraph, Mr. Laniado also pointed out that others at the meeting, including Mr. Rao, pathologists and so on, said they believed the case had been discussed and they signed the letter as well. MHPS investigator obtained 2 experts' opinions that stated the cancer was penile, not urethral, and that would have been obvious to the consultant. Investigator said, therefore...
Well, look, sorry, if you wanted us to read the whole page, it would be quicker for us to do so.
Yes,
I wasn't
please.
sure.
All right, read the whole, if you wouldn't mind reading the whole page then.
Yep.
So there we are. So there was supportive evidence for the conclusion that it was urethral and sufficient evidence to demonstrate that it had been discussed having regard to the number of people who signed it. Wasn't brought to an end in the claimant's case.
And you say that it wasn't a justifiable difference, what we see at page, on the last paragraph of page 121. That was Dr. Karim.
That was the
Who
allegation.
drafted it and recruited the 13 people to sign.
That was
You
the
say
allegation.
that couldn't justify the difference in treatment.
In my submission, no. Once the allegation, once the once there is no dishonesty or inappropriateness in the contents of the letter, then in my submission, no. If somebody's saying to Mr. Motawala, you have done something wrong, you've covered up an error that you made by treating a penile cancer patient in the MDT and not through the right pathway, there's nothing problematic about a consultant writing a letter saying, no, I was there, it was urethral, and this is what happened in my submission.
Yep.
Drew a line under that so far as Mr. Laniardo is
Just remind
concerned.
me of the date that it was not going to be preceded.
It's the 14th of November 2015, and you see that at page
and then
120.
how long did it go on against Mr. Karim?
2017.
What was the evidence, by the way, that the case examiners would know the race of Mr. Karim and of Mr. Laniardo?
Well, we cross-examined.
Mr. Karim has a name which suggests membership of an ethnic minority in South Asian.
We cross-examined on this a great deal. I mean, it was difficult because most of the decision makers weren't called by the respondent.
Well, you haven't told us who the case examiners here were and whether they were called.
I don't know if we know who the case examiners are here, do we? Graves was an investigator, not a case manager. I'm not sure we know.
I can't believe he didn't come out. I would have thought if their decision making is being said to be racially biased, he might have complained if they weren't called, but he must have been interested in who they were. No?
Well, perhaps we.
Okay.
Mr. Hare. Perhaps Mr. Hare. Mr. Hare doesn't seem to know either. Perhaps.
Well, if you're right that the facts give rise to an inference because the burden of proof is shifted and the decision maker isn't called, well, that's that, isn't it?
Precisely. Well, my lord, yes, that's what we say. The fact that one doesn't know the decision maker may be an important matter, but if the respondents decline to call the decision
Well, I
maker,
dare say, I'm not really making a point about this at the moment. I'm just wanting to know the basics. Do we know who they were? Then certainly were they called? Yeah. But I'm just surprised nobody seems to know the answer to that.
Well, I don't know.
Mr. Hare, do you know who the decision makers were and were they called?
We know who they were. Their names were put in the witness statement that was the witness statement of the case examiner who was called.
But this is a case examiner.
I know, but there are a number of case examiners, and each of the case examiner decisions involves two case examiners.
Yes.
There were the cases of 5 comparators, and it was considered it would have been entirely inappropriate to call what might have been.
Well, I'm not
12 and 20
sorry, look,
individuals.
I don't want to have an argument at the moment about who should have been called. I just want to know, is what you're saying that they were identified in the evidence, but they were not called?
Some of the so Mr. Smythe.
These ones in Mr. Laniardo's case.
I'd have to check that. I'm afraid I can't remember that, my lord.
Okay, well, could we just note that it seems to me, just as part of the basic facts, I would like to know, were the case examiners, there was presumably a decision to proceed in the case of Mr. Karim,
Yes.
also taken by case examiners.
Yes.
Were they taken by the same case examiners?
I don't believe so.
No, well, just I'd like to know what the evidence was about that.
Yes.
And I don't mind if they're called A, B, C, and D, just who they were and who was called to give case examiner type
I
evidence.
can answer that because we have at paragraph 101 of the Employment Tribunal's decision a reference to Mr. Smythe, who's a medical case examiner who was called by the General Medical Council and gave evidence about all of the case examiner decisions.
I see.
He also had in his witness statement a paragraph which set out the different case examiners. Now, my lord, I can't answer your lordship's question as to whether it named them all, but it did identify that there was a significant number of case examiners.
But did it say that whether the same case examiners took the decisions in the case of Mr. Karim as in the case of Mr. Laniardo?
I can't remember.
Okay, well let's leave it. Let's leave it. If it doesn't sound as though this featured very much in the submissions below, in which case it's probably a red herring for me to pursue
No,
it.
it's certainly not relied on by the Employment Tribunal that they say they didn't hear from the decision maker. But
Okay.
thank you, my lord.
Right. Thank you.
So just looking then through, you will see that the brought to an end in relation to the MDT. In my submission, tribunal are entitled to find, as an exercise of their judgment, that the situation or the circumstances were comparable as between Mr. Laniado and the claimant in relation to the MDT letter. And then CJ, page 123, bottom paragraph, where there's a conflict of evidence, it's not normally the case examiner's role to resolve it, but we can weigh the evidence to assess whether it would be capable of proving impairment. And even if it could be proved the comment was made, this is about the what Mr. Laniado said to Mr. Rao about what he saw about the prodding. It does not establish that Mr. Laniado actually admitted lying to the investigator, and so on. So no realistic prospect of success. Not meet the realistic prospect test. Only one other matter to draw from that. That is that Mr. Rao, the Rao allegation wasn't even considered worthy of consideration at all. It just seems to have slipped them by. So 2 overlapping allegations. One, get rid of it in 2015, not so with the claimant. And the other, don't pay it any attention at all. My submission, the tribunal are entitled to regard those circumstances as comparable as a matter of fact and judgment.
Is it relevant that Ms. Hollywood had made very different findings in respect of the 2 cases? And your client's claim is against the GMC. You're saying in effect that the GMC decision makers should have treated Ms. Hollywood's 2 reports, the contrast between the 2, as hopelessly tainted by discrimination.
No.
Well, what should they have done with them?
They should have identified the allegations that were made, identified what the evidence was that had been collected during the course of the investigations, and they did do that. We see that when we come to, in fact, I showed you some of it when we looked at the RPT decision in relation to the claimant. So they should have reviewed the evidence that had been gathered, and they should have undertaken any further examination or inquiries that they felt were necessary, and we saw reference to that in the RPT decision as well. But what they ought not to have done, that is the GMC, is relied upon the conclusions reached by Hollywood as part of a disciplinary investigation for the purposes of deciding whether or not there was misconduct for the purposes of its regulatory role. Of course, it can rely on the evidence gathered, but its job is to undertake a proper investigation. And it did so with MPT and Mr. Laniado. Hence, we see references in the Laniado closure report to matters we don't see explicitly within Hollywood, like the number of people who investigated, the histio, the sample, and so on. That was its function, but it wasn't entitled, ought not to have stood back and said, we're going to hands off. They had a duty to investigate if they were to treat the claimant in the same way. And of course, they could have done it. It wasn't said. They did it because they were hopeless or that they were incompetent, that is the GMC. And we do see defences like that. As your lordships know, well, it was an error, it was an oversight, somebody lost it, whatever. There was no suggestion of that sort. So it wasn't said, and we made this submission, that submission in our closing submissions. This is not a case where the respondent is saying, we made a terrible mistake here, we overlooked that, we should have done this, And then the tribunal would have to make a judgment about whether or not they accepted that or not. But that's not the case. And so we say the tribunal, as a matter of their judgment, the exercise of their judgment, were entitled to find that for the purposes of these two allegations, the situations were comparable. Mr. Laniardo's was shut down and the claimant's was not.
Now, suppose they were right that the different treatment of the claimant and Dr. Laniardo raised an inference of discrimination. What evidence could the GMC have called in order to displace that inference?
Well, it could have, I mean, obviously it depends on how they wanted to put the case, but they could have called evidence saying it was an oversight.
No, they say that it's not an oversight, this was the exercise of professional judgment. How many witnesses would they have had to call, and in how much detail would the two cases have had to be examined?
Well, the respondents choose to call the witnesses and adduce the evidence they wish to adduce and call. It's plainly not for the claimant to say what they could have called and how they should have presented their case. What we have are the bare facts, and the bare facts are Mr. Laniardo's white, the claimant isn't, two allegations, overlapping, pursued against one, not pursued against the other, difference in treatment, difference in race, where do we go from there? Now, the respondents could come back with all sorts of evidence. They could call the decision maker and say, no, it wasn't like that. What was in my mind at the time was X. And the reason I dealt with it like that was Y.
But they got all the paper anyway. We've got the decisions are very fully explained.
Yes. So they're not obliged to do so, but then it's the job of the tribunal to look at the contemporaneous material, hear any oral evidence they hear, read the witness statements and so on, and decide the case on the basis of the evidence that's been put in front of them. And the evidence that was put in front of them was that which I've already identified, closed down summarily, pretty much, and they remain in place for the claimant.
Can you just help me on this factually? Is there a continue the investigation documented decision equivalent to the, for Mr. Karim, equivalent to the discontinue the allegation, the investigation document in the case of Mr. Laniardo?
There are throughout the process, there are lots of documents showing what's happening at particular times. So what's being investigated here, what's being investigated there, and so on. So there isn't a let's keep it open document, but there are lots of documents discussing what should be investigated, what lines of investigation should be pursued, and so on.
I'm just a bit puzzled. I just want to understand how the procedure works. For some reason, the case examiners did a review of the case in, I forget the date.
Mr. Laniardo's.
In Mr. Laniardo's case.
End of 2015.
Was there an equivalent review in Mr. And if not, why not? Wouldn't the process generate the same kind of review in Mr. Karim's case with a different outcome?
Well, precisely. There wasn't any review. There wasn't any, these allegations cannot be pursued. They've come to an end. There was a simple pursuit of the allegations right up until 2017. So
what triggered the case examiner's review, which we've seen in Mr. Laniardo's case?
A case examiner decided it probably wasn't going anywhere.
No.
Could you just help me with this then? So 17th of November, GMC closed the case against, I'm looking at the chronology, which assumes agreed.
Yes.
29th of February 2016, investigation resumes. When Rule 12 process concludes.
The investigators, I'm told the investigators investigate. So they investigate for as long as they think it's necessary to investigate. It's then put before the case examiners to determine whether or not there should be a review, whether it should be brought to an end, whether or not it should be prosecuted, and so on. And we've seen the RPT thresholds being discussed at various stages.
Yeah, but so you expect to find one for Mr. Karim's case where it wouldn't have gone ahead?
My lord, there's the difficulty.
Do you mind,
is,
Mr. Hare thinks he knows the
I'm
answer.
sorry, yeah, I think there's a very short answer to this, my lord, which is why I'm very reluctantly rise again. There was no difference. The case was opened in relation to both Mr. Laniado and Mr. Karim under Rule 4 in 2014. The case was referred to case examiners then to consider whether or not to refer them to the IOP. They were both referred initially, and then there were further referrals for Mr. Karim. All investigations once opened under Rule 4 continue until they're concluded under Rule 8 by the case examiners. The case examiners aren't reviewing the investigation. The investigation is referred to the case examiners under Rule 8 to decide whether to close the investigation, as they did with Mr. Laniado, or whether to close parts of it and refer parts of it to a medical practitioner's tribunal, as they did in relation to Mr. Karim.
Well, okay, but that's the decision. That's the decision we haven't yet seen.
No, I appreciate that, but that's not my responsibility.
Well, there should be a decision in the bundles.
I don't think there's a decision.
So is that the 31st of March 2017?
Yes, exactly. That's the case examiner's Rule 8 decision in Mr.
And do we have that in one or the other of the bundles?
It's in our bundle, our supplementary
Sorry,
bundle.
forgive me. The first time that happens, and this is what the concern was, the first time that happens is in 2017. So yes, it happens, but it happens in 2017, and nothing happens before then. These allegations are pursued, remain outstanding, and the case examiners don't say, well, let's have a look at this and what's going forward and what's not.
So the real question is, yes, I see. What was there in the circumstances of the two cases that meant the case examiners felt ready for a decision in the one case in late 2015 and didn't feel ready for a decision in the other case until early 2017?
Precisely.
Yes, I see.
Precisely.
Hang on 1 second. Yes, thank you.
I'm going to flick over some paragraphs, mindful of the time, and come to what are the more central concerns. If I can ask you please to turn to page 118, Tribunal's decision. These have not been upheld, but to explain something that's arisen time to time. If you look at page 118, top of the page, in italics, there are two allegations, or two incidents of alleged less favourable treatment. Failure to approach Spire following the Charig allegation and to taking the matter up with Mr. Porphyry, and failure to consider the trust was manipulating the regulatory process to the claimant's detriment. Neither of those were upheld, but if I can ask you please to look at paragraph 56, a brief summary of the reasons. We agree the claimant must show some basis we could conclude that the respondent could or should have been aware trust was manipulating the process, and so on. I don't need, perhaps read the whole paragraph if you wouldn't mind, and then I can just pull out the point, which might be quicker.
Yep.
So while the tribunal is saying the particular allegations aren't made out, nevertheless, we are keeping in mind the fact that there was this pursuit of the Spire allegation with tenacity, as they describe it later. The case was put on the basis that this was the GMC scurrying around for allegations, complaints, pieces of evidence, and so on.
That's your case, is it?
Yes, that was our case, among other things. But our case, among other things, was they are making strenuous efforts to find things that are of limited, if anything, value, and where something comes that doesn't assist, they go back, which they
And
did.
did the tribunal agree with you?
The tribunal will agree with us that this is searching around, and when spies say there's nothing to see here, they go back to spy and say, well, is there something to see here, and so on.
Sorry, where do we find the finding that the GMC were effectively acting in bad faith by scurrying around finding?
I'm coming to those at the end because that's one of the matters on which an inference is drawn. So the
Yes, but that's later when the inference is drawn, but that must be based on a primary finding. And my lady's saying, where's the primary finding?
The primary finding is under the conclusions, where they... Would you like me to take you to that now? Okay, well, let's...
No, just give me the paragraph which we're going on with, like,
yes,
for my notes. That will do. I don't want to take you further out of your course than we already have done.
I'm looking at paragraph 109, page 130, but there is more than that. So
well, just take us through to due course. I'm sorry.
That's okay. That's
right. Where next?
And then, so then please, if I can look at, I'm going to try and get this through more quickly. I can leave the next section up to paragraph 60 and turn to the number 11 in our list, but just above paragraph 61, failure to interview Mr. Motawala, present during the conversation. And this is said to give rise to, or has from time to time been said to give rise to, an inadequate reasons challenge. Failure to interview Mr. Motawala, who was present during the conversation with Mr. Rao. And the tribunal deal with this at paragraph 63. Tribunal do not consider there's a credible explanation for the difference in the way the respondent treated Mr. Rao and Mr. Motawala in terms of gathering evidence in the claimant's case. So in other words, they interviewed Mr. Rao but not Mr. Motawala. Distinction in treatment in our view is explained by the fact that Mr. Rao was a critical witness of the claimant, while Mr. Motawala was a witness he might thought to have been helpful. They do not uphold that claim, however. So they're saying, in terms of the investigation, they're preferring evidence that they think might be helpful, but there's no comparison exercise and there's no finding in the conclusions that this was an act of discrimination. And there's no necessity for any further reasons. It's not upheld. And there can't be any complaint for them.
So why are you taking us to it at all?
Because it has been referred to from time to time as evidencing an absence of reasons. And we say there isn't. This is clearly not
I didn't pick this up I've read Mr. Hare's skeleton argument as being concerned specifically only with the findings
then I should jump through those as well then. So if we can then turn to, please, just bear with me.
Well, I see the time. Unless it's likely to be a 2 minute point, why didn't you just regroup?
Yes.
You mentioned several times you're concerned about the time. Obviously, the exercise you are doing is the crucial exercise of going through the Employment Tribunal's reasons. So in a sense, we don't complain. But I think it could perhaps be done.
Yes, I agree.
Now we've got the hang of how you're doing it in a slightly more, it's not a criticism, but a slightly more focused way this afternoon.
Certainly.
And I think please do focus on the findings which are the subject of challenge, except insofar as there's a real reason for focusing on anything else. Right, well...
may I just...
Yes.
May I just also ask my lords and my lady, again in the interest of time, would it be presumptuous of me to assume that it wouldn't be necessary to take you to cases like King, Anya, Shamoon?
No, we would have positively discouraged it, even if we had all the time in the world. These are very familiar cases. The key passages are set out in the establishment arguments. And this case is all about the reasoning of this tribunal against well-established principles. So no need to do any of that.
Grateful. That'll save me some time.